the potential spending of these users, these adult users, is potentially anywhere between 40 and 80 billion pounds. Okay, so that's a lot of potential business out there in the users that are just disabled. Okay, the UK law has actually been in place since 1995, so what, we're talking about 15 years now, nearly. Came into part as the Disability and Discrimination Act in 1995. It applied to some things, not all sectors of business. They then kind of released a second edition, or part 2 of it, in 1999, just before 1999, that kind of applied to all employment, so businesses and how businesses treated their staff and how businesses treated their customers. And then part 3 came into play just after 1999, which is to do with services and providing goods online, or providing goods as a business. A lot of part 3 is what we kind of apply to websites, and we're providing services as websites. We apply part 3 of the Disability and Discrimination Act of 1999 in that. Schools, colleges, universities, there's a separate section for those organisations that came out in 2002. Now, this is a document, it's very much a legal speak document that kind of lays out the terms of the law and what we should be doing in terms of the law. Associated with this document, there is also a separate set of documents called the Codes of Practice. And the Codes of Practice are more basically more layman speak, more readable. In what they do is they describe how this law is actually implemented and how it's interpreted. A lot of what you could read into in the Codes of Practice actually point towards websites. So if you look at just this document here, the Disability and Discrimination Act, it doesn't clearly say anything about websites. But if you have a look at the Codes of Practice documents, they do actually point towards things like online booking services and online services that we might be hosting on our websites. Right. The key things for us to basically take from the Disability and Discrimination Act is that it is basically unlawful for us as service providers, any services that we provide, for us to discriminate against a disabled person. Okay, it doesn't matter about the disability, any kind of discrimination, basically refusing to provide or not providing a service for a disabled user. So providing a service to an enabled user and then not providing the same service to a disabled user is against the law. We're talking about making it difficult or impossible for a user to gain access to the same level of service. That is against the law. Not providing the same standard of service. So I could, for example, have 2 websites. One website for disabled users and one website for enabled users. That potentially could be, if I'm not providing the same level of service, could be also against the law. And then finally, the terms of the service. So if the terms and conditions of those services maybe differ for a disabled user, once again, you're breaking the law. Okay, so basically our duties is to obviously uphold the Disability and Discrimination Act. The key thing to take from that, the laws, is basically that we don't offer a different service, a lower standard of service at all to a disabled user, but we are able to potentially, if we get questioned on the services that we're offered, we are potentially able to make reasonable adjustments to our services to try to make those services more available. Very rarely are you pointed at as a business and told that we're going to sue you right now because the service that you provided isn't accessible. Okay? It hasn't happened yet in the UK.
Actually, there's I was going to say it's the RNIB, but it's not the RNIB, it's the Disability Council. Anyway,
DRC.
Yes, DRC had taken 2 people to court, but they both settled out.
Yes.
In Australia, there was a...
Wait, I'm going to get there. Yes, I'm going to tell you. In Australia, Bruce Maguire succeeded. I'm going to talk about that in a second. There hasn't been a successful case in the UK. Like you say, there have been 2 court cases that have been taken to the courts, but they've been settled out of court. So there hasn't been a successful prosecution yet in the UK.
We're going to break the law tomorrow morning by putting this video out without subtitles. Is that correct?
Yes, you are.
That depends on how you're providing a service. If you're suggesting that you provide a service that should be accessible to people, then you would have to provide an audio track and subtitles. But surely just bang on.
We have
it in there.
We have to. We have to.
On YouTube, then you've not made any promises.
But because what we're doing is we're also providing that service on our website, so actually embedding that YouTube video on our website, and us being an academic institution in the UK, public sector, we basically should have closed captioning on every single video we put up online.
But the reasonable adjustment, if somebody contacts you by phone and goes, oh, I would have liked to have known what that said, but I can't hear it, you'll go, well, that's fine, I'll provide you a transcript.
Yes, and that's a reasonable adjustment. So somebody says to you, well, we can't access the service, right, we'll make that service available to you, fine, that's a reasonable adjustment. Okay? Yeah, well, no, that's where we're going to come to that court case in Australia. So in a second, we're going to get to that exact point. Basically, the service provider, anyone who's providing a service, has the duty of care. So it's not whoever's hosting the website or the web designer. In some cases, the web designer can be sued nowadays as well. So potentially in the States, there are a lot of cases where the service provider is actually pointing back at the web designer and saying, you didn't tell us, or the site creator and saying, you didn't help us or didn't tell us. And there are also IT suppliers not under investigation, but basically, if you are the provider of the service, in other words, if it's your website, if it's your company's website, you are responsible. Okay. Okay, this term, making reasonable adjustments, it's a term that is obviously very objective. I can say, well, what's a reasonable adjustment for an organisation the size of AxisCentre, for example? How many members of staff do we have? We have 4. If you say, right, what's a reasonable adjustment to us? It could cost us thousands of pounds to overhaul our website. A massive organisation, depending on the size of their website, it might cost only a fraction of their total year's budget to overhaul their website or to make a reasonable adjustment to a service. So basically, the term reasonable adjustment hasn't yet in the UK been defined in the court of law because everyone's kind of settled out of court. But in the courts in Australia, which Nick has kind of, they have settled a case. And the reason why this is actually important to us is because we kind of fall under the same kind of law. We have a Commonwealth law. They have a Commonwealth DDA, and the Commonwealth DDA and the court systems in Australia are quite similar to the sort of systems that we have here in the UK. So basically what happened in 2000, just before 2000, 1999, a gentleman named Bruce Maguire, who was a visually impaired user, so he wasn't able to see, he basically went onto the Olympics.com website, tried to get information about the upcoming Sydney Olympics. And he found that it was impossible for him to read a lot of the content across the website. He had also made requests for other paper literature and that sort of thing, and he basically put in 3 cases against the Sydney Olympic Committee for discrimination against the Commonwealth DDA. Basically, these cases, he had reported them. The cases were looked at, they were seen by a court, and the court basically said to the Sydney organising committee, said to them, make adjustments to the website. They basically said, no, we refuse to make adjustments to the website. They had basically said, the adjustments that you require us to make are unreasonable. For us to make the adjustments to the site, basically going into all of the scheduled sports pages and all the scheduled results pages and making changes to them, basically changing the table design, the way that the tables were marked up, going in, changing those so that they're more accessible. Also making their images accessible. They didn't have any alt text, any alternative text on their images, especially the navigation images. So, for example, they had buttons that had services on it, for example, and schedules and sports names and that sort of thing. They didn't have any alt texts on that. So the screen reader that Bruce Maguire was using couldn't actually read those alt texts, couldn't actually navigate the site literally at all.